Hi, this is Thomas Plunkett. I am going to dive into a presentation dealing with issues of copyright law and generative artificial intelligence. And in particular, I'm going to take the focus in this particular uh, presentation, looking at it from a perspective of content creators who are using generative AI as a tool to assist them in creating content. What are the issues regarding copyright law and obtaining copyright protection for these content they're creating using generative AI as a tool? All right, so the first one I'm going to talk about is some artwork that Stephen Thaler used a generative AI system to create. Um, this is artwork showing a tunnel. The title he gave this artwork was "A Recent Entrance to Paradise." Now, Stephen Thaler actually worked on building a generative AI system, and the system he created actually has created lots of artwork, and this is one example. And he sought copyright protection for this particular artwork from the U.S. Copyright Office. So here's what the Copyright Office did. They rejected his request for copyright protection. Now, in applying for the artwork, he listed his generative AI system that he built, that he was very proud of, as autonomously creating the artwork. He said his Gen AI system created the artwork with no human involvement. Now, the Copyright Office follows U.S. law. U.S. law comes from the Constitution, it comes from the Copyright Act and other acts of Congress, and it also comes from the courts and how they interpret the laws and regulations. And some of those laws were created the Copyright Office, which then applied what it believed to be U.S. law in examining this copyright registration. Now, under U.S. law, it's believed that non-human entities cannot receive a copyright. So animals, the Holy Spirit, and so forth, if they're listed as the author, they don't receive a copyright. So if you're submitting the Bible for copyright protection, you should have a human author. Or another religious text, as opposed to listing God as the author. If you submit a copyright registration and you list your dog or your cat as the author of the work, again, the Copyright Office will not grant copyright protection. So Thaler was refused. He sued the Copyright Office. And they went to the U.S. District Court in D.C., which hears lawsuits against the Copyright Office. And the U.S. District Court also agreed with the Copyright Office. Now, the U.S. District Court, when it's reviewing the Copyright Office, it's basically acting like a court of appeal. It's checking to see if the Copyright Office followed its rules or if they were arbitrary and capricious in what they did. And the U.S. District Court basically stated that it looked like they were following their rules. Their rules basically say that non-humans can't receive a copyright, and that in this particular case, because Stephen Thaler asserted that the artwork was created without human involvement, therefore, following that rule, the artwork can't receive a copyright. Now, this case has been appealed to the DC Circuit, which is a court of appeals above the district court, and there was an oral argument in December, and we'll probably see a result in that case by May or June. And then, of course, again, it could be appealed to the Supreme Court after that, potentially. Although the Supreme Court only hears certain cases, they have discretionary appeal, so they may not take this case, even if Stephen's representatives try to appeal it. Well, here's another case. Christina Castanova created a graphic novel using the AI platform Midjourney to create the graphic artwork. She wrote all the text, and Midjourney, in exchange to her prompts, generated the artwork. And she listed in her graphic novel herself as the author of the text. You can see Castanova up there, and Midjourney as the artist. So the Copyright Office actually registered the work, but then she made some posts on Instagram and so forth and social media. And after seeing the social media posts about how she had received a copyright for the work, the Copyright Office actually retracted the full copyright they provided and modified it slightly. So the Copyright Office is very resistant to granting copyright for generated content as we saw, where an AI is actually creating the content. If a human author is creating the content, the Copyright Office is fine with a human author having created the content. So Christina used Midjourney to create artwork to accompany the text for the creation of her graphic novel, which is Zara the Dawn. The Copyright Office granted that the author has a copyright to the text, and they also granted that the author has a copyright to the selection, coordination, and arrangement of the written and visual elements. For example, if we look back at our text, selecting the images, putting where the text goes on the images, and so forth. Um, the Copyright Office did not grant her a copyright for the individual generated images. So, for example, if we ignore the text up there for a moment, this generated image of the city here, or the generated image of the postcard without the text, they did not grant her a copyright for that. The Copyright Office believed it was Midjourney that originated the traditional elements of authorship for the generated images, and that the users weren't controlling the output, but rather Midjourney was. So, to go back to our graphic novel for a moment, imagine that Christina had hired an artist, and that artist had painted these various illustrations traditionally. Well, in that case, the artist would have the copyright for the illustrations, and Christina would have the copyright for the text. Now, if the artist was working in a work for hire format, then maybe that copyright would then transfer to the organization that employed the artist. However, in this particular case, the Copyright Office is taking the position that AIs, since they're not human, can't receive a copyright, and therefore no one gets a copyright to the generated art. She had legal representatives who argued against the Copyright Office. Her arguments were that she authored the entire work, with Midjourney just being an assistive tool, and alternatively, that the text is copyrightable and the work is a copyrightable compilation due to her creative selection, coordination, and arrangement of the text and images. The Copyright Office went along with number two, but rejected her claim to copyright the individual images and rejected the idea for her argument number one that she was the author of the entire work, with Midjourney just being an assistive tool. So let's talk a little bit about copyright law, and then we'll dive a little deeper into what's going on here. So the U.S. Constitution, Article 1, Section 8, gave Congress the power and responsibility to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so this section really gave rise to copyright law, patents, trademarks, and so forth. In order to implement this, Congress created the Copyright Act, which you can find in U.S. Code in 17 U.S. Code. Section 102 provides some definitions where it pointed out that works can be registered for copyright purposes if they are original works of authorship fixed in a tangible medium of expression. And a tangible medium of expression can be pretty broad, whether we're talking photographs or books, magazines, artwork of all kinds, movies, and so forth. But a play would not be. But the script for the play would be. Original works have to be independently created by the author and have sufficient creativity. And that's really where Gen AI is going to have issues. Works with no or only a minimal amount of creativity, such as a phone book, don't qualify for copyright. Now, photographers who use cameras can receive a copyright so long as the filming process isn't a completely mechanical process. For example, a stationary mechanical camera that films everything might not have sufficient creativity for a copyright to be granted. Although, in fact, just about all film these days is given a copyright. So there was a famous Supreme Court case where that established that photographers' work did qualify for copyright purposes. Prior to that case, photography and film was actually questionable as to whether or not you could get copyright protection. And so I think what we're dealing with now in generative AI is very similar to the situation that photographers faced prior to the Supreme Court case that recognized that photographers could obtain copyright protection. So if a work contains AI generated material and you're an applicant for copyright, you should disclose the presence of AI generated material and provide a statement describing the human author's contribution. The Copyright Office tends to view prompts as detailed directions without influence on how those directions are executed and insufficient for granting a copyright. So, what you need to do is you need to show their view is wrong by showing how the detailed directions influenced how the directions were executed, and therefore you should qualify for receiving a copyright. The copyright is looking at it from a perspective of if you just provide instructions to the machine and you selected an output, that doesn't equate to authorship. So instead, focus on use of AI as a tool as opposed instead of as a means of generating expression, and you're more likely to be successful in claiming copyright protection. So there has been a formal report on this topic, as well as a number of other documents that have been posted to the Copyright Office's website. Their January 2025 copyrightable report is a formal report that summarizes industry comments as well as the perspective of the Copyright Office. It's actually part of a three-part series on industry comments and the Copyright Office's perspective on copyright and AI. Part one was on digital replicas. Part two, that just came out in January of 2025, was on copyrightability. The report is pretty similar to the two examples I just went over, but goes into a few more details a few more examples, as well as a lot of perspectives on different industry commentators. Some people argue that AI companies don't need copyright protection because they're making so much money. That's in the report. Others argue that without copyright incentives, less content will be created, and therefore we ought to give copyright protection. Personally, I believe that's correct. I think the issues we're facing are very similar to what went on with photography and film in the early days of not providing copyright protection for those mediums. And I think just like we eventually provided copyright protection for film and photography, we will eventually provide copyright protection for generative AI content. Just a few comments on copyright law in general. You should, provide copyright notice if it's applicable. Registration isn't necessary to obtain a copyright, but registration is practically required if you want to sue an infringer for infringement. Um, and open source software is still a copyright. So if you're utilizing open source software, you should understand how that open source license impacts products that build upon open source software. The current term of copyright is life plus 70 years. The copyright subsists from the creation and lasts for the life of the author plus 70 years after the author's death, or 95 years from publication. And so for works made for hire, it's actually 95 years from publication or 120 years from creation, whichever comes first. And Congress has extended the copyright term a number of times, and they may well extend it again in the future. All right, well, thank you for attending this brief presentation on copyright law for generative AI content creators.